tonight. I will ask you to think back to last year, the parking lot when it was really hot, not this last time, but the primary, the Republican primary when we were out there. How many of you worked the parking lot or walked our voter guides around or did some things for that election in the Republican primary? Raise your hands. Okay, very good. So a whole bunch of our candidates won at that point. And one of the candidates that won at that time was a real shocker, a real shock to the system. And that was Kelly Case, who defeated longtime Judge Fred Edwards. And things are quite a bit different now. And so now I have the pleasure of introducing Judge Kelly Case from the 9th Judicial District Court. Please come on up, Judge Case.
I have a little presentation. I'm going to go through it, kind of show you some changes we've made, but I wanted to talk just a few minutes about this juror that I had arrested. We had tried 2 previous times to seat a jury. We started with 72, we busted that panel, we went up to 100, we busted that panel. It was a very contentious case. It caused a lot of strong feelings in jurors. So I told the lawyers, we're going to go for 150 this time, and if we don't get 150, we're going to have to try this case out of the county. Cost goes through the roof when you do that. So I really wanted to avoid that at all costs. So in Montgomery County, the clerk's office tells the courts when we can have jurors available. I don't agree with that, but that's how it is. So we could only seat jurors, talk to jurors from Tuesday on. We couldn't use the room because no other rooms in the county have enough room for 150 people. So we had to use the jury assembly room because it was being used on Monday to divvy out the jurors to the other courts. We had to use it on Tuesday. So we got there Tuesday, the temperature was about 90, it got up to about 100 around lunchtime. Very hot day, no air conditioning in the room. Monday, we had gotten calls from 8 different people, all with valid excuses, ranging from one man his spouse had a brain tumor and she was scheduled for surgery. We had people that had would cause financial destitution to their families if they had to serve on a jury for more than a week. Legitimate excuses. And then we got a call from a teacher, and this is what she said: I'm a teacher and I have to take a student somewhere. Well, my staff got the call and said, no, unfortunately that's not going to be good enough. Show up, explain to the judge, and he may or may not let you off, I don't know. It's going to depend on how many other people show up. So the first day was spent in heat and miserable, and I had to break. We just couldn't go any longer. So I told the sheriffs, I signed an order, a writ of attachment is what it's called. I wanted her brought to court the next day to explain to the other 145 people in the room why she thought she didn't have to be there after being told to be there by my staff, and didn't feel like she had to do her civic duty. So they arrested her that night and put her in jail, and nobody tells me. I didn't find out until the next day, about 11 o'clock. I asked my bailiff, hey, are they going to bring that juror in today? And he said, oh no, she was released last night. I thought, oh boy. I went back to my office at 1, we had finished picking the jury. We got through almost the 100th juror. We only had 120 after all the excuses were done. We got through the 100th juror before we seated our 14th juror. I always pick 2 alternates. So we were close. We needed every available person. So anyway, after the catastrophe of errors and she was arrested, I found out later all this other stuff, that she was taking care of this child that was a cancer patient and all these other horrible sympathetic things. But I'm going to tell you, if I had to do it all over again, I would have done the exact same thing. Because I don't feel like, just because you don't feel like you want to show up, as I was talking to some of the other people earlier, jury service is always inconvenient. But it is literally the only way that we can do what we do. If we don't have jurors and we can't try cases, you're going to have the situation that this court had when I got in there. You're going to have people sitting in jail for 4 years waiting to get to trial. Now, let me win my presentation. That's my juror explanation. If you have any questions, I'm happy to answer them. So when Dr. Turner was talking about sympathy to the media, I have no sympathy for the media. they play it their way. How do I advance the?
There you go.
That's it. Okay. There you go. There you go. Okay. That's it. Got it. When I was running, I made four, I call them promises, 4 pledges basically. I was going to do my best to do these 4 things. The first one was I was going to try and reduce the court's budget by $100,000. I thought that was very, very manageable and it could be done. I also was going to be a full-time judge. I wasn't going to show up at 1 o'clock or 2 o'clock in the afternoon and have attorneys waiting on the county payroll. And I was going to show up sober. I didn't list that, but. And I was going to hold dockets on a regular basis, and I was actually going to try cases. It doesn't sound like a lot for a judge. I mean, you know, the bar was set pretty low. I was also going to, my main push was to reduce the amount of time for cases to resolve. When I was doing my research on the court, I found 2 people that were in jail for 4 years waiting to get to trial, and 1 person that had been in jail for 3 years waiting to get to trial. These were not capital murder cases. These were the 2 that I noticed for 4 years were 2nd-degree felonies, and the 1 that had been in there for 3 years was a 3rd-degree felony. These weren't cases that should take that long. But you get attorneys in the county indigent system that are appointed. We have a lot of really good attorneys. A lot of really good attorneys. But when you have 50, 60 attorneys, there's always going to be 1 or 2 that abuse the system. Resets get you more money as an appointed attorney. So they would reset and reset and reset these cases. So my goal was to reduce the amount of time for these cases to resolve. I want to talk about the first one, reduce the budget by $100,000. So far, through combining salaries, getting rid of positions, basically the structure of the court, thus far, already I've been able to cut out $80,000. Now I haven't quit, I'm still looking. Okay, I'm going to find that other 20, but here's the situation. When I got into court, when I got on the bench on January 1st, the accounts were all drained. We had no money for printing, we had no money for paper. Everything had been totaled out. So I had to go back to Commissioner's Court and ask for a little money for printing because we needed some paper and toner. Sounds ridiculous, but that's what I had to do. We are working on a shoestring right now. I have less employees, I have a court administrator, and I have a court reporter, and that's it. I don't have anything else. I don't have anybody answering the phones when we're in court. We have, the administrator has her own cell phone that forwards all the calls to her phone, and I allow her to take those calls in court. I believe, this is my personal philosophy, that if you are flexible enough, allow the attorneys to pick and choose their dates and when they want to appear, we're going to get them in there and we'll get the cases resolved quicker. So far, it's working out. We're in our 5th month now, and I don't have any cases since I took the bench that have gone on longer than 5 months. All of my cases have now resolved since I took it. The older ones that are set on the trial docket, we still have several that are 3. We have 1 that's 4 years old, and we have several that are 3, many that are 2 years old. Have all been put on the trial docket, and all the attorneys have been told, you will go to trial. It's inflexible. I put a policy guide on the internet, which I'll talk about a little bit. They know what to expect. And what you'll find is, and I know Judge Myshawk back there will agree with me, what you'll find is when the attorneys know they're going to trial, and they know that they have to show up and resolve their cases, guess what happens? They do it. But if you let them reset and get that extra $100 or $150 for that reset, it's just going to keep happening. So, and I have to say, I stole the idea from Judge Myshawk. It's her idea. I give her full credit. But it works, and it works very well. And it doesn't mean that you have to take the pound of flesh out of everybody when they come to your court. You can be very nice about it, you can be very polite, but you insist that once they put those cases on the trial docket, it is not negotiable. That is your trial date. So far we've reduced the budget by $80,000. We have less employees than any of the other courts. Now I will say this, we are specialized. We handle only criminal cases. And the reason that occurred was a couple of things. The main push from this came from Judge Gilbert, the administrative judge. And I felt like, as a board-certified criminal lawyer, that was probably a good thing for me to do, was take over the criminal docket. I don't want to say I have an immediate understanding of where the attorneys are going, but because I've been doing it for so long, I can cut through all of the wasting time and get down to the necessary things. So it's a big help. Judge Myshaw's court is also criminal specialized. She's a very good criminal prosecutor and then defense attorney. So what you're going to see is, over time, these courts are going to consolidate. We have now 2 specific family law courts. We have, I know, 1 specific civil. Do we have another one? I know Judge Wood. Judge Laird, that's right. Judge Laird does specifically civil stuff. And Judge Hamilton, who works around the clock, constantly, handles a combination of things. So you're going to see the courts kind of shifting into this more specialized mode, and what that does is that promotes huge efficiencies in the system. Because if you have civil, family, criminal, maybe a drug court or a DWI court that you handle, you only have 4 weeks in a month that you can get jurors for each one of those types. We're getting anywhere from 200 to 300 cases filed a month. We can't possibly get through all those cases. So specialization really helps promote more efficiencies in the system. And you should see a reduction in cost. Whether that happens or not, I don't, I'm not responsible for the commissioners. I can't say that. But that's the theory behind it. I didn't remodel the court. A lot of judges, when they come in, they do this big remodeling thing. I thought that was a waste. Our courtroom is not the best. It's not set up to be a courtroom. Judge Myfox is the same way. We don't have holding cells for prisoners. We have to have the prisoners seated on one side of the courtroom, shackled and in chains, and we have to have the people on bond sitting right across from them, begging them and pleading them, don't talk to the inmates, and inmates, please don't talk to these people, we have to remove them. It's not the best system. The explanation I had when I got here is, well, nobody's died yet. So we don't have holding cells. It's not really a courtroom. But again, no remodeling expenses. The only thing we did, and for some reason we didn't have any furniture in my court. I don't know why, but I had to buy some furniture, some chairs and some other things for people to sit in. They just weren't there. We also were missing 2 laptops that mysteriously got up and walked off from December. The Rangers are running those down, and I'll let you know as soon as they find them. The new budget is scheduled to be submitted by July 2013, this July. We've already kind of got the preliminary numbers in, and like I said, we're still hunting to try and reduce. I'm hoping to make the 100,000, but I'm not going to guarantee I can get there. We've got it at 80 now, and I'm going to stand firm on that. If we can get more cut out, we're going to definitely do it. It takes a long time, and I am not an accountant. And for me to have to get the explanation of what these funds are and what they do, truly and honestly, I don't understand what the auditor does. I really don't. They talk about moving items from one line to another, and that's supposed to mean something. I'm not an accountant, so I'm working my way through it. I've got a lot of good help, but it takes time. At the beginning of the year, yeah, I told you that, our accounts were drained. We had nothing, and we're currently operating on a shoestring, but we're getting it done. And we're getting it done. Everybody's in a good mood. The staff is great. I hired really good people. That was, I have to give my wife credit for that. She told me who I should hire. And she made good choices. The administrator's great. Rebecca Tomplay, I'm going to show you how to get in touch with her if you need to get in touch with her. And the reporter is actually the reporter in the court before. Fantastic. We are now doing live transcriptions for trials, for first degrees and above. My reporter will have live transcriptions for the attorneys. It's a tool that helps you when you're in the middle of a trial and your client's life's on the line. Stress gets very, very difficult in those cases, and the trial could last 3 or 4 weeks. So we decided we were going to offer that for the attorneys. All right, second promise I made was I was going to be a full-time judge. So far this year in 2012, we've had more criminal trials and punishment hearings than the court did all of last year. In fact, I can tell you that the previous 2 years we've held more hearings and trials than the court ever did. So, and I still don't have a full load of cases. My caseload was only first and second degrees. So when I got on the bench, I took back all of the criminal cases, which are we call them state jails, or we call them 4th degree felonies, all the way up to capital murders. We have a full load. But we're getting assigned, I think it's 2/7? Is that right, Judge? It's 2/7 of all the criminal cases I get, and Judge Myshaw gets the same 2/7. It's just this rotating system of appointments, or I should say assignments. So we're trying to stay ahead of the curve and not let things get too backed up. so far we've been able to do that, but we're not anywhere near 100% yet. So that's important to keep in mind. As I said previously, the court only heard first and second degree felonies. Those are obviously your more serious cases. They don't take up a lot of time. The reason I say that is most of the time they plead out. Usually they don't go to trial. If they do, it usually is a lengthy trial. I also have the swear engine case, which is taking a long time, and 2 capital murders that are currently pending. The state is moving for the death penalty on one of those. So we have some time-consuming cases. We're getting through them. We don't have those lower cases, those state jail low case drug cases. Some theft falls into there. Those are really the bulk of any criminal court's caseload, and we don't have a lot of those yet. We're starting to get more and more. I'm going to talk about the drug stuff in just a little bit. So what I did was I decided that rather than us just sit idle and me getting smarter and smarter from reading and researching all the time, we would try and help out. And so we've offered to take other cases from courts that couldn't quite reach their full trial schedule. If you have 7 cases in the trial, you might not make it to the 7th one. Probably make it through the first 5, they'll plead or something will happen. But we want to be sure that we're filling in and taking those cases, because what happens is the county will have to, the judge can decide, and none of the judges, with a few exceptions, will hire a visiting judge, which means we have to pay another judge to come in, sit, hear the case till the case resolves. None of us do that. We have now 3 associate judges, one of us that Judge Myshaw can rely on consistently, that if something happens, like this week, I think you had a case plead, is that what? Yeah, Judge Myshaw's case pled this week, so she didn't have another trial, so she's handling her docket full time, and that associate judge is now handling my docket while I'm in this massive punishment hearing. So it works out really well. We're able to bounce off of each other and help each other out, and what you'll see is more and more of these cases getting tried that are really, really old. I'll talk about that in a little bit. Also, all of us that are up there now, Judge Myshaw's court's right across from mine, and then Hamilton's is to the left and down the hall. All of us are, it's kind of funny, we don't ever talk. I don't ever see any of them. This is the first time I've seen Judge Myshaw in over a month. I know you think that we talk and we have no conversations with each other. But we are all working together and with the state and getting these search warrants out and volunteering to assist on weekends, after hours, at all times. So I feel like, and maybe Judge Myshaw could correct me, I feel like we've got a good group of people in place that are all willing to work together, and it seems like it's more cohesive for the district courts than it ever has been before. I don't want to claim that's because of me. I just think that because of the shift in dynamic of personalities, that it allowed that to happen. We all are trying to work hard. So we're volunteering. All right. Hold dockets on a regular basis. Previous administration held dockets. They said they held them every week. Again, if the judge got there by 1 o'clock in the afternoon, it was a surprise. So that went away. When we have a 9 o'clock docket, I'm there usually way before then. I take the bench at 9, start calling names at 9 o'clock. We know who's there and who's not there. That's something that wasn't done before in that court. We have trials scheduled every week, beginning on the Monday. At this time, we have all of the 4-year and 3-year-old cases lined up for trials through September. We will clear everything out by the end of September. So those people, we have, like I said, I think 3 or 4 people still left in jail that have been there more than 3 years. All those cases are going to be tried by September. If I can get to them sooner, I'll move them up. But so far, everything's going to trial that we've scheduled. Trials are scheduled, and juries can only be selected on Mondays. This is a problem for me. This is the clerk telling me when I can have a jury trial, and I feel like it's the tail wagging the dog. If I finish a trial on Tuesday or Wednesday, why not have another jury panel ready to go, get the next case lined up and go to trial? Why do I need to wait till the next week? At this time, they're telling me I can't do that. The alternative is I can call people in to be there on a Wednesday, but they have to show up on the Monday be sworn in and told to come back on Wednesday, and the cost to the county goes up because I've had to pay them for the first day and the second day of jury service before we've ever started anything. So that needs to change. It's you know, the response, and I'm sure Gable got sick of it within his first week, it's the way we've always done it. But it doesn't make any sense. You know, I fight that battle on a daily basis. So hopefully that's going to change in the upcoming year or maybe 2 years. And I think what's going to spur that on is a new computer system that we have going into place, new software system for the whole county. Currently, my court mirrors what Judge Myshaw does. I think what she did is great, and I don't need to recreate the wheel. We have dockets on Tuesday afternoons, Wednesday mornings, and Thursday mornings. If we need to bring people back, we have the rest of the day to do that. We need a hearing for punishment. We have a hearing on a restitution amount, hearings on anything, motions for discovery. We can do that on those off periods. And so far it's been pretty full. As I said, hearings can be held on days between trials and in the afternoons. Court begins promptly at the time it's supposed to. Take the bench, I start calling names. People aren't there, I'll give them 30 minutes to show up. The ninth is not in the same place. It's not fair for me to hold somebody if they go to the other courtroom and they're late coming to mine. I'll give them a break. But if they don't show up within 30 minutes, I issue a warrant and they're taken into custody. Promptness, I believe there's a couple of, I believe that a lot of these people have trouble managing their lives. You're talking about people that you guys have never had any contact with. These are criminals. So we manage their lives in certain areas for them, and one of them is being to court on time. I give everybody one freebie. I let them out of jail one time. You know, talk about how I do that. But after the freebie, I ask the DAs if they don't show up on time again, or they're not following the conditions that I place them on to be on bond, we no bond them, which means they will sit in jail until the case is disposed of. They get one freebie, and that's it. We've been able to reduce the time so far for these cases to resolve. Trials are prioritized with jail being first, but then you have to take into account how old the case is. If a person's recently in jail 2 weeks and you have a 2-year-old case, you're going to take the 2-year-old case first. These are our local rules. I don't have any say in that. It makes sense, and I follow it. We have, at this time, I know, I can remember off the top of my head, we've already gotten rid of 2. I think we have 2 more cases that are 3+ years old. People sitting in jail waiting to go to trial. Those have been set. The latest one is in September, and the attorneys already know that you're going to trial. Get ready, there's no excuses. All of those cases are going to be concluded by the end of this year. I think there's one that's not actively on the trial docket yet because we have an out-of-town attorney that has not shown up the last 5 times we had this case set. And I talked to Judge Myshaw and I said, you know, this is ridiculous. When I got hired to defend somebody on a case, I was there before the courtroom opened. First of all, talking to my client. Second of all, ready for whatever business needed to be done. I can't imagine just not showing up. We have this one that does. So he has been sent a notice of trial and told that he has 4 days to contact the court to reschedule that trial to conform to his schedule. And if he doesn't, that's it, set in stone. In my court, I have discovery procedures. And I'll tell you, I had a few problems with the previous district attorney's office not turning over things when they should have. So in my court, we have actual discovery hearings, and all the cards are laid out on the table. They have to file a packet, it's a big 3-ring binder of all their evidence, so we know exactly what's seen by the defense, and they don't get to hide anything. If they don't get all the evidence in by the Code of Criminal Procedure 2801, if they don't get it in by the 2801 hearing date, the evidence does not come in. I had too many photographs that appeared on the day of trial. I had too many exculpatory things that were never disclosed to me, so that ends. They turn over everything the way they're supposed to, and there's nothing wrong with that. A lot of people, they say, oh, you know, why does the DA have to turn over everything? That's what the law says they're supposed to do, so they do it. My order, once they're on the trial docket, becomes inflexible, and it's set way in advance. We have hearings, they know it's coming, there's no question. What I mean by being set in advance is 2 weeks before, is the minimum time we can have that hearing. 2 weeks before, they know who's number one, who's number two, and who's number three. There's a good side and a bad side to that. And I don't want to waste your time going into all that, but basically, if number one shows up and says, "Oh, Judge, I can't go today, I'm not ready," I look at him, I say, "You knew you're number one, you have two choices. You can plead your client and take the deal if the DA still offers it, or you can sit there silent, but we're going to trial." I haven't had any problems yet. That's, again, I stole that from Judge Marshall, so hey, Judge Marshall. It works. Advance notice on everything is really important. So again, they reduce the time for cases to resolve. This is something that was not being done. Now, it's common sense when you have a person, they picked up a drug case, possession of a controlled substance, they're released from jail, usually the next day. They don't have to go to court. They didn't have to for 6 weeks, sometimes 8 weeks, because a piece of paper that they completed at the jail had to make its way over to the district clerk's office and then make its way up to the district attorney's office. 6 weeks, okay? You have not taken these people out of their lives. You've not removed the problem from them. To them, it's just an overnight stay where they got a free meal, okay? So that's how the court was doing it before. I worked on this for a long time, and I again, selectively pilfered from Judge Marshall and decided there's no reason why we need to wait on a piece of paper to tell us when somebody's going to be in our court. We instituted a way of, we came up with a way of doing it where now they appear within 1 week. And that has a lot of benefits because, first of all, it reinforces in them, oh boy, I got a felony case. When they see the bailiffs there, sitting there, telling them to sit down, line up, get them in order, court doors open, and I'm calling names, people are getting thrown in jail, people are getting out of jail, it's more real to them. They get a little, believe it or not, people get a little felony dope case, and it's not a big deal to them. They might not even show up, because what's the big deal? So, another way that I reinforced it, and I, again, stole this from Judge Marshall, everybody gets tested for drugs on your first setting. That means, and you would not have believed, when I first took the bench, there were more than 70% of these people that were waiting 6 weeks to come in. Methamphetamines and Xanax, Somas, all that stuff, but meth was horrible. More than 70% of the people coming into my court on the first time tested positive for meth. Whoa. So now they know. Drug tests, automatic on the first time, random for every time thereafter. Now, if they're charged with theft or tampering with a government record, you know, and a third or fourth reset, I'm probably not going to test them. If they're charged with possession of cocaine or delivery of cocaine, they're going to get tested quite a bit, and it works. Because you get rid of the people that can't be on conditions of bond, they're out there committing new crimes, and you get them put into jail, and they're held there. So our jail is only filled, in my court, with people that need to be there. They cannot follow the rules. That's the theory. As I said, on the first positive test, I give everybody one chance. I'll stick them in jail for 1 week, and then I'll pull them back out, and I'll reinstate their bond, and I'll tell them on the record, if you do this again, and you don't follow my rules, I will ask the DA to set a no bond hearing, and we will hold you in jail if I find that there's grounds for no bond until this case is over with. That could be 6 months down the road. That's real to these people, okay? They don't want that. Second positive, as I said, no bond, it works. It's working great. I've only had to have 2 no bond hearings and make sure all the inmates that are in there go back and they're talking to all their buddies, oh man, Judge Case will throw you in jail for 6 months, don't violate his conditions of bond. And they're not. It's working. I'll show you the numbers in just a little bit. When I first got into court, the only way you could communicate, or the only way any of the probation department, any of the other departments could communicate with the court was through a written memo. So by the time the court got notice that somebody was violating their conditions of their probation, they had already been sentenced, put on probation, and they're out there continuing to do drugs or beat their spouse or whatever they're not supposed to be doing, you would have, the probation officer would have to sit down, write a detailed memo, send it to the court, have to be processed through the court. It might be 6 weeks. I got rid of all that. Now, probation departments and any other of the other police departments or anybody that needs to get a hold of me, email me. I'll get right back to you. So we're having this instant communication. Warrants are going out the day we learn of a new offense for somebody on probation. The warrant goes out that afternoon. It's immediate. I think the quicker that you can do those things, the better off it is long term. We are filing motions to revoke. Previous administration, while motions to revoke were filed, would never revoke anybody. So far this year, I've sent one person away for life, and I sent another one away for 20 years, and then some various in between. I believe in giving everybody a chance. I'm a soft-hearted person. I make the trials as fair as I can be. But if you're found guilty, there is a reason for the maximum, and that is my belief system. If you can't present to me some reason why you shouldn't go to jail for 20 or 30 years, you will go to jail for 20 or 30 years. And I go home and have a cup of coffee and talk to my family. I'm sympathetic, but I'm not stupid. I know a lot of these people have gotten breaks and breaks and breaks, and they just keep doing the same things over and over and over, and it has to stop. If you talk to Constable Gable, they arrest somebody, and the next night, that person's back out on the street doing the same thing again, and it's got to stop. I'm not infatuated enough with myself to believe that I'm going to stop it. I know how it works. But if they know that there's a judge who will put them in prison for a long time, it might cause them to hesitate and think a little bit. That's the goal. As I said, I allow the attorneys to pick and choose their day to appear, and I do require their attendance once they appear. We're very easy about resetting cases. I allow the attorneys, they can call into the office and do it, as long as we have a signed reset form. I allow them to show up and sign on behalf of their client. And the reason that I do that is because I believe that if you're working with them, they will try and get things done. As I said, 99% of these guys are hardworking just like the rest of us. It's that 1% that ruins it. So I'm trying not to make the rules based on the 1%. At the beginning of when I took the bench, I published a practice guide so that all the lawyers, defense and prosecutors, knew what to expect. Surprisingly, I'm still reminding them that the practice guide is on the internet. They just don't look at it, so they get caught by surprise. But it's working, it just takes time. As I said, we have mandatory drug testing on the first appearance. We do the first setting within 1 week of their release from jail. I hold them accountable. Conditions of bond, if somebody's released from prison, say they have a charge of a possession case. You have on there, that the way I do it is, I have them random urinalysis exams. They're going to report to the probation department once a month, check up on them, make sure they're following, not staying out of trouble, not getting any new offenses. That's another condition, not get a new offense. There's not a whole lot of conditions they have to follow. If they can't follow those few conditions, they don't need to be out on the street with the rest of us. They need to be in jail. And that's the theory behind that. So ancillary conditions of bond are these things they have to do and things they must not do in order to remain out on bond and stay out of jail. Another thing, as I said, I file and hold motions to revoke probation. I have no favoritism in who I appoint. Now I have 2 or 3 attorneys that are my close friends. They don't operate in my court. I don't think it's proper. But I don't do anything to interject myself into the appointments from the county's wheel. What I'm talking about is somebody who's arrested that's indigent has the right to have an attorney appointed to them that's paid for by the county. It's a big expense, and so I don't feel like it's my call to decide who's appointed. We have a separate office for that. I stay out of that completely. If you know about how the court was run before, you know that's a change. I make myself available at all times for warrant authorizations, and we've started holding continuing ed workshops in order to increase our efficiency and output. What I mean by that is, we have a lot of services, social services, mental health services in this county that are not being utilized for our population that needs those services. A lot of the attorneys don't know much about mental health cases. We only have about 9 attorneys qualified to handle people with mental health problems that are accused of crime. So my court is trying to combine the services and the attorneys and help them understand what all is out there. So hopefully people that don't need to be in jail can get out of jail and get treatment, get on their meds, get what they need, and get back to where their lives are stabilized. I talked to you earlier about the positive effects that I believe getting them into jail right away has. And this is backed up, and I've only been able to gather 3 weeks of data, so I wouldn't put much stock in this. When I come back after 6 months, then I think we'll have a better number. And last week, my numbers were
blown up. Before that, they were only about 5%. You'll see what I'm talking about. We've decreased positive drug testing from around 50% to 23%. Last week I had 5 out of 7 people test positive, so it blew my number up on the 23%. What happens is, when somebody's arrested and they're taken out of their situation, their life, they realize there can be consequences. If you don't follow up with that right away, get them on conditions of bond, or get them into jail, or excuse me, get them into court right away, they revert back to the way they were. And there's been no reinforcement that they need to change. So our goal is to try and reinforce to them, you've got to change right away. And that's one of the effects that we're seeing. We have a decreased recidivism arrest rate. What I mean by that is, we had anywhere from 25 to 35% of those people that we had out on bond committing new offenses. And I'm not talking about 1 or 2 new offenses. When they're on a crime spree, we're talking 10 and 15 things they're doing. So my purpose in shutting down after they violate my conditions the first time, putting them in no bond, is get them off the street, because something's going on. They're going to kill somebody sooner or later. It's working so far. We've had a huge decrease in our recidivism arrest rate. I don't have the numbers yet, but I've looked at it. I've seen the stats that we have. So far it's good. It's just not significant enough to report. FTA is a failure to appear. That's somebody that's given a court date, they don't show up. Self-explanatory. What happens is a warrant goes out, bonds are forfeited, a lot of things kick into gear when the FTA is issued, and none of them are good. They all cost the county money. What was happening was, people were given one date from the jail, they'd show up to court, we had no idea they were coming to court. Nothing there. So when we switched to our new system of forcing them to be there 1 week after they were released, now we have accountability. We know they're going to be there. We haven't had any of the same problems. So it's working. We don't have the FTAs that have been issued. I think I've had 2 people in the last 3 weeks that didn't show up for the first court setup. That is phenomenal. I mean, we were having 10 and 12 people a day not showing up. The benefit is, if the clerk has to issue a warrant, the warrant goes out, and then Constable Gable has to go out and serve that warrant. It's all time and money that's being spent and taken away from things that they could be doing that are better, more necessary. So hopefully we've reduced that. I, again, don't have numbers to tell you that for sure, but so far looking good. We've got better monitoring of our ancillary conditions of bond. We've got improved reporting immediately after the release. And we've got an overall improvement in the fewer repeat crimes, which is the second violations and the no bonds. I'm hoping are the reason for that. I cannot tell for sure. We've made a lot of changes in the way we handle things, in the way we deal with people. And before, we're very, very accessible to the public, which is good until the media decides to portray something that it's not. But we're accessible. And so if you have any questions, or you ever want to come in and take a tour, watch a docket, see what actually happens in a court, as opposed to what happens on CSI and the TV, you're welcome to contact me. My administrator is Rebecca Tomplay. Her email's there. The court reporter is Rebecca Lewis. She just got married. Her former name is Chapman. Or call a court. Any of us will handle your call. As you can imagine, I don't talk to everybody that calls, but I try and keep my fingers in the pot and know what's going on. So if you call and tell me you're with the Tea Party and you want to come up and visit and see what the court does, I'd love to have you. I believe in open government, transparency, and I want you to know what's going on up there. The real what's going on up there. Do y'all have any questions for me?